I'll leave it to the panelists to change around the microphone because I think you can all hear me. Is that right? Thank you. What I have to say is not as important as what these four people have to say, so it makes it easy. So I'm Counsel for Demand Progress. I wanted to thank the Transparency Caucus for putting this event on, specifically Representative Quigley's office. I don't know if Hannah's still here. Really happy to get a chance to talk to you all about this. I'm going to keep my part of this as brief as possible because, again, these are the four people who were brought in to see and talk with you all. So there will be time for questions and answers at the end and also after the panel if anybody wants to talk. I'm sure people will be interested in staying a little bit longer and getting to questions if we don't have time during the session itself. So without further ado, going to ask all of you if you don't mind just doing one-sentence introductions, not full remarks or anything, but just so that everybody knows who you are.
Yeah. Hi, everybody. I'm Liz Hempowicz. I am the Project on Government Oversight's Policy Director.
Hi, my name is Newland. I am counsel at Protect Democracy. I spent a little over 2 years working at OLC.
Hi, I'm Kel McClanahan. I'm the Executive Director of National Security Counsel. I'm a private attorney who deals a lot with stability.
Hi, I'm Mike Stern, formerly the attorney with the House General Counsel's office, and I write about congressional legal issues and point of order.
Thank you all. I'm standing for the microphone. Please use it to the extent possible, but I understand it's a little bit unwieldy. So I wanted to start this off. Quick question. Who here is inherently familiar with OLC? So before this panel, they came in knowing you know what Office of Legal Counsel is. Okay, so there's a bit of, I'm going to say, foundation laying to do, which is really important and why we wanted to do this panel. So I'm going to kick it off actually turning to Liz. Liz, can you tell, just as a starter measure, what is OLC? What do they do? Why is it important?
So it's a relatively small office at the Department of Justice that provides legal advice to the president and to executive branch agencies. I think that is that is the extent of what they say publicly on their website is their job, as well as weighing in on potential executive orders and presidential actions of substance or something. I forgot exactly the operative phrase. But I think the reason why we're all here today is because they do a lot more than just weigh in, and essentially they end up setting policy for the executive branch through their legal opinions, which they issue and don't necessarily publish for the public or alert Congress to their existence. So I'm jumping ahead to some of my issues with OLC, which you'll hear a ton about today anyway. So I will pass it back to you, Sean.
Thank you, and I'm going to invite the whole panel to add on to anything that they hear that they want to add on to, generally speaking, so I don't know if anybody wants to add to that. Michael?
So the OLC is delegated the Attorney General's authority to issue legal opinions. And so that's where their power comes from. Essentially, they can issue legal opinions that are binding on the executive branch.
And that part is actually one of the big issues that a lot of people have with OLC, where agency heads and agency officials of various agencies will say that they are bound by OLC legal opinions, while if you try to, for instance, sue under FOIA for OLC legal opinions, they will say, oh, it's just advice that lawyers are giving clients, and it's privileged, it's non-public, it is not binding on anyone because they are free to ignore our advice. And that's a big tension and a big sort of way of having it both ways that is going on right now, which is my pet area of interest.
And so Kel just did a great job foreshadowing some of the issues we're going to dive into, but also keyed us up for Erica, who has really specifically important experience in this context. And I was hoping you could tell us a little bit more. When does a piece of paper turn into an OLC opinion? What does this process look like from the inside? And whatever experience you'd like to share here is more than welcome.
Yeah, so OLC creates a lot of different types of work product. Some of it's sexier than others. So part of what OLC does is review executive orders for form and legality. This is what Liz was talking about. That typically isn't done through what we would think of as an OLC opinion, like the type that is posted on the website. That's done through what's called a form and legality memorandum. There are examples of some floating around that have been released via FOIA. For example, the one for the travel ban. OLC also writes bill comments, which are just comments on the legislation that is being produced on the Hill, flagging constitutional concerns. One thing I think everyone here flagged really important roles of OLC. One additional thing worth emphasizing is that OLC openly embraces a role of protecting the prerogatives of the presidency. Now, that's not the president as an individual. That's not even kind of this president necessarily, whoever this president is at the time. That is the power and prerogatives of the presidency as an institution that lasts over generations. And so when it is, for example, objecting to certain congressional legislation, it's whoa, 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 you're trampling on on the president's constitutional prerogatives. That's kind of an important to recognize that lens. Whether it's the right lens or not can be debated, but that's the lens that OLC openly applies. OLC also issues a lot of informal advice, what's known in the office as informal advice. You can see examples of this also floating around that have been FOIA'd over the years. This will be, the White House will call up and say, can you give us your thoughts on this? Or an agency will call up and ask a specific question, whether it's about statutory interpretation or an area that OLC has cultivated a certain expertise in. The Emoluments Clause, for example, OLC has cultivated expertise in over decades. There's an opinion floating, a piece of informal advice out there authored by Sam Alito back when he was at the office, before he was on the Supreme Court. And then OLC also writes things that become formal opinions. And these are presented as, and I think thought of as, a lot more like judicial opinions, rigorously researched, rigorously site-checked, rigorously checked to make sure there's 2 spaces in between each sentence, things like that. And these are the things that sometimes end up getting released to the public. You see a list, of these on the back of one of your handouts here. Those go through a more rigorous vetting process, and are often signed by either the head of the office or one of the deputies, kind of second in command. And those have stronger precedential value. I guess that's the last thing I'll say. But the informal advice also has precedential value because it shows the views the office has taken on something. But one thing that I think is very important to recognize is that the opinions, which are often the focus of a lot of conversation about OLC, are a small percentage of the day-to-day work of the office. I think that informal advice, the executive order review, the bill comments, that's often taking up a lot more time and is forming a real substantive and often kind of important body of precedent for the executive branch.
Can I jump in here?
Yes, please. But let's go with Liz because she asked.
All right. Points for politeness. I want to go back to something that Erica said at the beginning about kind of OLC's role in responding to congressional offices to give feedback on legislation because, and I may be jumping ahead again a little bit, but I think this is one area where they're kind of operating in a way that's maybe not so transparent, comes back to really hurt the public and congressional offices in particular, because as Erica said, they give this advice with the prerogative of the presidency in mind. But I think that advice is usually treated by congressional offices as a standard interpretation of the law that should be followed. And we talked earlier about the binding nature of some of OLC's products. They're not binding on you. It's not binding on Congress unless, I think especially if OLC gives you comments on a bill that are just referring back to previous OLC opinions and not to legal opinions. I think you should be looking extra skeptically at that. And I like to tell people, mostly being glib, but also with some seriousness there, that if you could gather a few attorneys in your office to put together a counter brief, like you should give those two the same legal weight when deciding what to legislate from your office, because unless the Supreme Court said it, it's not binding on you. And so I did just want to say, just flag that. I think that's one of the areas where for us, at least, we're very frustrated years down the road to hear that legislation was crafted around OLC opinions that aren't really rooted so much in the law as they are in protecting the presidency.
I'll jump in just really quickly to clarify one thing I said, which is OLC is providing input into what the Office of Legislative Affairs at the Department of Justice is providing. So those actually aren't labeled as coming from OLC, they're labeled as coming from the Department of Justice. This administration has been putting a lot of those online, or some chunk of those online. You can find them on the DOJ website as views letters, which is something you all might be familiar with.
And getting to the point, and I'm glad that the first question where Vitka pointed out, trying to make, which was the position that, we're protecting the prerogatives of the president. This is something that actually gets them into, at least with those of us on the outside, a lot of trouble, sort of conceptually, because it's another dichotomy between, not just between is it controlling or not controlling, or this one is sort of what is their role? Are they the executive branch's lawyers, the way that I am my client's lawyers, or he is his client's lawyers, or the House General Counsel is your lawyers, or are they, as their own document says, frequently asked to opine on issues of first impressions that are unlikely to be resolved by the courts, a circumstance in which OLC's advice may effectively be the final word on the controlling law. When OLC was first set up, way back when, it was designed to be like this in-house objective legal analysis outfit that would basically act as an impartial judge and write sort of this is what the law says, that could be trusted in situations where it would be not likely to go to court. When that position is sort of put at loggerheads with we are representing the executive branch, we are not representing sort of what an outsider might say, then it starts to cause a lot of tension. And that's where the Congress has problems, that's where courts generally have problems when DOJ cites to an OLC memo in a brief to a court. And the judge is as likely as not to say, that's nice, you just gave me the opinion of your lawyer, of course it's going to be in your favor.
I want to make sure, this is very helpful and illuminating. Erica, I wanted to go back to you because you drew a couple of lines, and I think it's important and maybe not something that people will get a chance to hear much about. So you mentioned formal opinions, and it sounds like maybe that's where most of the focus is for the rest of the panel as well. Can you describe what's the difference between an informal and a formal opinion? You talked about the guidance. It looks like people in this room may not even know it's coming from OLC when they get it, if it's also going through the Legislative Affairs Office. What is the significance of getting to the end of that road, to that formal opinion?
So there's actually a way in which I am poorly positioned to answer this question, because having been on the inside, I can't speak to the significance of a formal OLC opinion to the outside, right? I can speak to it to the inside. It is so there are some things that are more likely to happen with a formal opinion. If it's going to be overturned or ignored, there is an enormous amount of pressure on the office to make sure to be public about that, to not have a formal opinion out there that's stating one view of the office while another one is out there. So for example, about a year ago, OLC overturned an opinion from the Obama administration about another OLC opinion from the Obama administration about the Wire Act. And, the first one had been public. That meant, there was some sense of like customary obligation on the office to be public about a change in that position. And the formal opinions are, more likely to end up being released publicly.
Is an informal opinion still binding on the executive? I mean, Liz was talking about the impact it has on the executive, so.
It is.
It sounds maybe not.
Yeah, I mean, within the office, they were generally treated as precedential, and you see that in the public statements where they're being referenced as precedential. And sorry, I'm just choosing my words carefully here. No, not at all. And in the perception that I always had with talking with other folks within the executive branch was of a lot of respect for OLC and a lot of respect for anything that was coming from our office. Now, whether that was because they felt legally bound to treat it as, to treat it that way, or it had to do with the customs and norms of the executive branch, I wasn't actually in a great position to evaluate that. So I will leave that to the others.
I can tell a simple just anecdote. I was at a roundtable event with several senior agency officials, with several of the people in the audience here. And the general counsel of the agency said something about how, and since OLC's opinion was binding on the agency, it was, his hands were tied. And that was the first time in my experience a few years ago that any agency official had literally said, we are bound by an agency opinion, or we are bound by an OLC opinion. And I called him up a couple of days later and I said, I'm going to write something about this because you just proved the point that I've been trying to make in litigation, that y'all feel bound by these things. And he walked it back really fast and he said, well, no, we're not bound by it legally. We're bound by it because I read it and I agreed with it. And that's the type of, the sort of hoops that they used to jump through. Then this year, you have Robert Mueller saying, I am bound by a DOJ policy, and the policy he cited to was an OLC opinion. You have the Inspector General of the intelligence community saying that he was bound by an OLC opinion about whether or not something was an urgent concern. And he didn't agree with it, but he was bound by it. This year has been a real sea change in that, where they're coming out and saying that out loud.
So I think there's an important kind of set of distinctions to possibly draw here, or just to be aware of, within the Department of Justice. So what Robert Mueller was saying was, as an employee of the Department of Justice, he's bound by Department of Justice legal interpretations. The Attorney General has delegated that authority, as Michael said, to the Office of Legal Counsel, and therefore it's binding on him. There are other situations. I'll use the emoluments clause again as an example, where where Congress has delegated to the Department of Justice authority to prosecute people who have violated the Emoluments Clause or at least violated the Foreign Gifts and Decorations Act, which has a lot of overlap with the Emoluments Clause. And so questions about that come to OLC, and because at the end of the day, it's DOJ that has that prosecutorial power, or that enforcement power, I guess I should say, to be more specific. And so their agencies are interacting with DOJ and with OLC from different perspectives, depending on kind of the governing laws and just the layout of the executive branch. Yeah.
So let me go back a little bit to the way OLC conceives its role. It is true that it has what it calls the best practices memo that goes back to 2010, which Kyle has there, I think you alluded to earlier, that basically says they are in the they are in the business of protecting executive branch prerogatives to a certain extent, but that they are not in the business of simply advocating for the executive branch. So theoretically, OLC could take the position that we're in a Madisonian system of 3 branches. Our job is to make the best legal arguments in favor of the executive branch, and Congress has its lawyers. They can argue for that, for whatever, and the judicial branch will decide cases when it comes before them. But they do not take that position. They take the position that they will give the best view of the law, even if it conflicts with the interests of the president or the executive branch, while at the same time recognizing they're situated in the executive branch, and they are looking at things in some sense from an executive branch perspective. That's a very subtle distinction, perhaps, but it's important because to the extent that OLC opinions have any influence on anybody outside the executive branch, it's based on this idea that they are top quality lawyers who are providing, in some sense, a neutral exposition of the law. And I think there is a good deal of reason to believe that that's not actually what they do, particularly when it comes to conflicts between Congress and the executive branch.
I would love to just,
And then I'm going to throw hard stuff.
yeah, okay, connect that to the point that Liz made earlier, which is, this concept of ambition, this Madisonian concept of ambition countering ambition, which, is what Michael is acknowledging is, I think, part of, is very kind of part of the lifeblood of OLC. And there is an ideal, one could say, even a fantasy, that that OLC goes to the mat for the president's view, and Congress should go to the mat for its own view. And what Liz is pointing out is that sometimes it feels like, and I recognize who I'm speaking to here, sometimes it feels like a kind of one-sided fight. And one of the things that that I think Congress can do in figuring out how to engage with the work product coming out of OLC and the decisions being made by the executive branch is to speak up and fight back. And there are different, I'm sure we'll talk about different ways to do that, but there is kind of power in y'all's hands, and I think part of how OLC conceptualizes itself or pretends to is that Congress will fight back, while maybe sometimes preventing Congress from having the tools it needs to do so. So that's also a topic we could discuss.
Yeah. And Congress can't fight back if they don't actually know what OLC has said.
Yes,
Right.
yes,
So that's a problem.
yes.
So before diving into all of those topics, well, laid out very well so far, I wanted to take a moment because it's easy to get lost in this as kind of an academic debate. And so I want to take a second and ask each of you to just talk about one OLC opinion that you think everybody should know about this. And it can be because of the process around it, or the impact of it, or there are some goofy stories out there too. Since I'm getting grunts from everybody else at the table, I'm going to switch to Liz.
Well, I'm going to start, I don't know if this is certainly not my favorite or least favorite OLC opinion. I think it depends, right, it depends on the day and what I'm mad about then. But right now, I think the one that really catches my attention is that something I learned relatively recently, that the Ethics in Government Act, so the law that says that senior government officials need to comply with the ethics laws that Congress passed, famously does not apply to the president. We've heard that a ton over the last 4 years. I'm sure we will keep hearing that. That goes back to an OLC opinion. That doesn't go back to anything that the Supreme Court has said. And it may well be unconstitutional to apply ethics laws like that to the president, but really the arbiter of what is constitutional and what isn't constitutional hasn't weighed in on that. And so the idea that we accept that and we've legislated around that, and legislation has gone downhill from there, and just accepted this idea that we can't apply these laws to the president, it all goes back to OLC. And then if I may just throw out a second one, why not?
I want to throw out two as
right,
well.
there you
so-
go. Okay, good. Is the testimonial immunity question, and I go back to that one because a judge just a few months ago really eviscerated that in an opinion, and I just like to go back to it every once in a while and read passages back to myself to just gird myself for the fight for transparency around OLC opinions on the daily. So that is one of my other notable ones. There was an opinion basically saying that that senior advisors to the president don't have blanket immunity from testifying in Congress, because even after they leave, there's this, and that's a newer opinion, right? So there's a few of them now, but the latest iteration, I believe, is that even after a senior advisor has left, they're still covered by this immunity because the future advice they give to a president may now be in question. So it's really not very logical.
And to your knowledge, has that prevented people from testifying? Is that enough?
Yes.
Oh, yeah.
It sure has. It sure has, because, and sorry, I don't
No,
mean to
please.
monopolize, but I
That's
think
why
it was
John
actually
Bolton is not.
Yeah.
right,
come
and I
to
think
He's
actually
cited to
the First Branch Forecast did it earlier today, called OLC opinions a presumptive pardon. So you can follow if you follow the law as OLC lays it out, the Justice Department is not going to go after you for not following the law, because you are following the law as they see it. And so, yes, it certainly has stopped people from testifying to Congress because they can point to this opinion saying, I am totally in line with what the Department of Justice believes are my obligations, and I haven't done anything beyond that.
There are a lot I could choose from. So I'll trust some of the other panelists. Okay, so last night, as one does on a Sunday night, I was reading the Kosovo opinion. It's from the Clinton administration. And one of the lines in the opinion is that it would be unconstitutional for one Congress to bind another Congress. And therefore, the plain text of the War Powers Act kind of has to be read as a very soft presumption rather than a command about how to interpret legislation. And I thought Congress binds itself in the future all the time, whether through rules or through laws. And I have to say that struck me as a particularly illustrative example of what it can sometimes mean to protect the prerogatives of the president over, maybe the plain words of Congress. Another one that just drives me crazy is this recent one about the Treasury Department's obligations to hand over the president's tax returns. Again, the law's clear language says that the Treasury Department shall do this, and OLC's justification is really focused on congressional intent and says that the congressional intent was not pure, not sufficiently pure, was too political, and therefore Congress cannot actually invoke this law. And, perhaps there could be an argument for that, but what was so frustrating about it was that OLC has, especially in recent years, like much of the judiciary, taken the view that intent, at least in the executive branch, doesn't matter. I mean, you see this in all of the Department of Justice's arguments about the travel ban, but also before this administration, you see it in a lot of different places. And so the kind of have your cake and eat it too, we get to not have our intent taint things, but congressional intent can always taint things. When a legislator's intent is, as many conservative jurisprudence will happily point out, is far harder to ascertain than a single unitary executive's intent. That just made me want to pull my hair out.
So, first of all, I'm a national security whistleblower lawyer. So you can probably where I'm going with my first opinion. Some of you may have heard that there was an OLC opinion that said that it was perfectly A-OK for the acting director of national intelligence not to forward a certain whistleblower's complaints onto Congress. And the arguments that they gave for it were dubious at best. But the problem that I had most with that argument was not necessarily that they took this hardline executive branch rah-rah position. It was that they went way beyond the role that a lawyer would normally do, to the point where they were doing things like including, and he might have been biased, and he might, there was something in it about how he might have had a connection to the Biden campaign. All of those things do not have any place in an opinion over whether or not something rises to an urgent concern that has to be reported and who can make that decision. But because they were acting, and I'll say it, because they were acting as the White House's lawyers, they acted the way that you would act if you were making an argument to a jury instead of writing an objective legal opinion. The second one is the genesis of all of these arguments. It is something called common legislative encroachment on executive branch authority. And this is a tome of an opinion that is basically a manifesto about all the horrible things that Congress does to get in the way of just God-fearing executives trying to do his constitutional duty. And that's actually one of the ones that got revoked in a positive way. The first one that came out was really bad, and it was written by a guy named Barr. And then it got replaced by a newer one that took a slightly softer tack and is basically being ignored in favor of the previous one now, for obvious reasons. And so if you want to sort of, from a congressional perspective, look at, you want to know what OLC is about and how OLC views its role in the world, especially when it comes to Congress, go read that opinion.
So,
Did I steal yours?
no.
Okay.
Actually, Liz would have stolen mine because my favorite would have been the absolute immunity opinion that she referred to. But fortunately, OLC has come out with a new opinion that supersedes that one as far as I'm concerned. And so you may recall back in October, the White House, when the House began its inquiry into the Ukraine matter, that the White House counsel sent a letter to the Speaker and various House committee chairs saying that the administration could not cooperate in any way with the investigation. They had a number of reasons for that, and many of them were just purely political, not even sort of semi-legal. But there were some legal arguments that they made as well. And basically saying, so, we're not cooperating with this investigation at all. So, as you may have heard, that ultimately resulted in the president's being impeached. And during the Senate trial, when the parties filed their briefs, the White House brief came with a attached OLC memorandum that basically, which is dated January 19th, 2020, but purports to memorialize advice that was given several months earlier. But it doesn't exactly say when several months earlier it was given. What it does say is that the subpoenas from the House came, the first one came on September 27th, then there was a series of other subpoenas going up to October 10th. One can tell from the OLC memorandum that the advice was given sometime prior to October 31st, which is when the House passed a formal impeachment resolution. The gist of the OLC advice was that because there was no formal impeachment resolution at the time of these subpoenas, they were not valid. The question is, though, when exactly did the OLC come up with this opinion? The earliest they could have been, according to their memo, they were asked for their opinion sometime after the issuance of the subpoenas, which is what is stated, but it doesn't say when they gave this opinion. It's almost impossible to believe it was given prior to the time that the White House counsel wrote on October 8th that we're just not cooperating at all and this whole thing is invalid. And if that's the case, it's hard to see how OLC could have given any kind of neutral, objective opinion when the president and his lawyers have already taken a definitive stance on this issue. If, on the other hand, they gave this opinion verbally prior to the time of the letter, it also raises a whole bunch of questions, such as how long did it take them to come up with this opinion? The opinion purports to be based on a review of nearly 100 House impeachment investigations dating back to the 1790s and going all the way through the present day. And did they do that review like overnight, or what exactly? How exactly did they come up with this opinion?
They were preparing for him to be impeached for a while.
Well, that's a possibility. Definitely a possibility that they were preparing this. But they did specifically say that your request came following the issuance of the subpoenas. So I think it raises a whole bunch of issues, including the question, what exactly is OLC's role in an impeachment investigation? Is protecting the interests of the executive branch and the presidency the same thing as protecting the interests of the president as someone who may be impeached? Is that, do they draw a distinction? How do you make that distinction? So that is I have a lot of questions about that memo and how it was prepared, and whether anyone in the office raised objections to it as not being in compliance with their best practices guidelines. I think those are questions that Congress should be asking.
Thank you all for each of those. I'm going to use moderator's privilege for one more. It's been one of interest to me for a long time, and I think it also serves to show that these are not new concerns for the record. So under President Obama, there was a drone strike of a U.S. citizen named LHOB. This was, I think, one of the. If you heard about OLC opinions sometime between the torture program and the impeachment, it might have been about this. And in that scenario, it was President Obama, the administration generally decided to drone strike a U.S. citizen overseas. That opinion was not public when that drone strike was executed. That opinion was not public by voluntary nature. That opinion, well, the executive director was, but it took a huge amount of political force and power and exertion to get that out into the public. So I'm going to move on for time purposes. I'm going to switch to Kel McClanahan as our first answers for this one. Is it hard to obtain an OLC opinion? So hopefully we've substantiated the question of are these significant? I think that's the goal up until this moment. Why should you care? Hopefully you care about some of this. And I might say that there's probably people you work with who care about these other issues. What's the big deal?
Is it hard to
Obtain
get one?
Yeah,
For us to get
for
one.
Congress to get.
Oh, you mean to lay your hands on it,
Right.
not to ask for it. I see.
Well, to know what it says.
Right.
So I will. So yeah. Okay. So let me say I was in, as I mentioned, the House Counsel's office for about 10 years. During my time, at least as best I recall, we didn't have a lot of issues about secret OLC opinions. At least I'm not recalling any. The big controversy about that actually preceded my time. And was came from the first Bush administration, when the Justice Department had issued something called, I forget what the formal name of it was. It was referred to around our office as the Snatch Memo. And what it dealt with was the authority of the FBI to go into foreign countries and arrest people who were allegedly in violation of U.S. law without the consent of the host government. And it became a big issue with Noriega, with the apprehension of Noriega in Panama. So the Congress was, again, this was prior to my time, but Congress was trying to get a hold of this memo, and the Justice Department was saying, no, you cannot have it. And it ultimately was subpoenaed by the Judiciary Committee. The administration still refused to provide it. And what they argued was that it was an attorney-client privileged document as opposed to executive privilege. So there was a big fight about that at the time. Eventually, there was an agreement reached where the members of the committee were allowed to go and see the memo, but they weren't actually allowed to take copies. I'm frankly not sure even to this day if it's been made public. But anyway, so that was a big controversy. I think the current. So anyway, so during my time, this was not a big issue, but we did have a related question when the second President Bush came out with an executive order on presidential records. And one of the problems that members of Congress on both sides, it was Republican Congress, but members, both Republican and Democrat, had a huge problem with this, with this executive order. And one of the reasons was it listed a bunch of reasons that presidential records could be withheld, and they were not limited to what Congress thinks of as executive privilege anyway, which is presidential communications, state secrets, things of that nature. It also included deliberative process and attorney-client privilege. And we had a big argument with the White House counsel's office and the OLC at the time, which were headed by Brett Kavanaugh and John Yoo. They weren't heading the offices. Well, I think John Yoo might actually have been heading his office, but they were in charge of this issue and basically arguing that common law privileges like attorney-client, while they may very well apply in FOIA litigation or civil litigation, they are not a basis for withholding documents from Congress, and they're not a constitutional privilege. And their argument was that it was part of executive privilege to be able to withhold attorney-client privilege matters. So I'm not sure that answers your question, but that's my background on that question.
It's definitely helpful context, and I'm actually going to, for time combine a little bit our next question, so we're going to start with you again, Kel, and just let her go back to So in addition to, is it hard to obtain these opinions, congressional and public approaches, and like just give us some Congress perspective, how do they come to this? How do they come?
So, well, I can hit the first one first. And I'm going to hit the thing you just said first, and I'm sure that she can go into it in more detail. Most OLC opinions come to light because OLC decides we're going to release it, we're going to publish it. They have their own little review process that is very opaque to us on the outside, that they decide which ones get published to the rest of the world, and they get, in many cases, put on the website. There's a giant PDF of old ones going back to, I think, the 30s and 40s that they made. You can find them if you're a lawyer and use like LexisNexis and Westlaw and those. There is no consistency which ones are on which portal. And in fact, a few years ago, I had a very overworked intern go through and do a compare and contrast, and found a whole bunch that were on Lexis that weren't on Westlaw, but were on DOJ's one website, but not in their PDF, and it was just all over the place. That's how they generally come out. You can force them out rarely, for the reasons that the way you would normally do that is through FOIA, and they do take the position that I alluded to earlier, that everything is attorney-client privileged because they're just, lawyers doing their job and giving advice to clients that nobody has to follow. And so most judges will go along with that. Once in a while, you sort of push it out. As an example, one case that's really illustrative of this, where I did manage to get an OLC opinion out, was that I had sued OLC for a bunch of opinions about sort of how FOIA worked and how classification worked. And there were two that were withheld. There were a bunch that were withheld. But I went into the National Archives, into their files, and I found an unedited, unredacted copy in their files that the Attorney General had accessioned into NARA. And the Attorney General being the client in this case, and yet OLC was withholding it.
You mean
Given to NARA, accession means you give to NARA to be published. And it was published, and it was buried in a warehouse next to the Ark, but it was there to be found. The other was an opinion about whether or not CIA could do this thing called could charge for mandatory declassification review, which I won't get into. But the then head of OLC, by the name of Antonin Scalia, had gone and given a briefing about this opinion to the people that he wrote it for, and those minutes were published by, again, the client, the head of ISOO at NARA, the Information Security Oversight Office. I had to prove to the judge that these things had been previously released, and only then did OLC release them. And even then, they argued that they had done nothing wrong because it was not their job to check with their clients and see if the things had been released before withholding it under attorney-client privilege, which is not how attorney-client privilege works anywhere else. But that's currently in the D.C. Circuit being appealed. A small aside to that. In 2015, a bunch of OLC opinions, basically every OLC opinion from before 1985, was slated to be given to NARA, to be accessioned, taken out of OLC's hands and put in the hands of the archivist. They are not yet there. We have complained to NARA about this for years. And NARA says, well, we can yell at them, but we can't sue them, we can't force them. And so even without resorting to FOIA, the things that anybody should be able to walk into NARA and read, they can't because OLC is just ignoring their responsibility to turn over the records. So that is how hard it is to get OLC opinions for those of us who aren't in Congress, and it's only slightly easier for those of us who are in Congress.
Yes. So, Kel, you're talking about FOIAing OLC opinions. But it's hard to FOIA something you don't know if it exists. And so one thing that we did at POGO, may I steal this?
Yes, please.
So I never get visuals when I do these things, so I want to use the visual even if I didn't bring it. So one thing we did at POGO was FOIA just for a list of the titles of OLC opinions issued within a certain date. And what we got back initially was this top of this paper here. So it's almost entirely redacted under B5, which is the deliberative process. Goes back to what OLC says, this is not binding legal advice. This is just advice from a lawyer that you are free to follow or not follow. But it's so sensitive that we can't release even the title to you. We appealed that and we got back this lower list, which is much more transparent, as you can see. And we found the titles of what they had withheld as like being so sensitive and that releasing it to the public, even the title would have been disruptive to OLC's role in providing legal advice to the executive branch. The titles were so sexy and secretive, such as a memorandum of who can serve on the Centennial Commission for JFK. So it's like none of this stuff is meets the bar for B5 redaction, and instead it just kind of shows really the reflexive redaction and secrecy around these opinions when there's really no reason for secrecy, and instead it just raises all these other questions of what else are you hiding that you're not doing such a bad job at that we could just get it overturned with a FOIA appeal.
Considering how much legal impact these opinions have, I don't want to lose sight of the fact that FOIA is a complicated process. The process often requires a lawyer that you're doing it with an organization. But do you have any thoughts on what, is this, tell us that a lot, most of these are proactive, yes, historically in particular, but what do you think of that?
No, I mean, it's true, and I would say that the Trump administration is doing a really good job of proactively releasing them. The problem there is that we can't really tell if they're, I say they're doing a good job, but I don't actually know that. I only judge that by what's on the website, and it looks like they're putting out more. I assume they're pretty busy these days. But we don't know because we don't know what they're withholding. It's up to OLC, it's up to DOJ to decide what they put out there. And frankly, I mean, I know I'm a transparency advocate, but I just don't trust them to be making the best decisions when we receive FOIAs back like this. And so no, I don't think it's a very easy process, and it's easy to say, they're more transparent or less transparent, but really we're just kind of shooting in the dark on this. And that's why I think it's, even if the public can't receive kind of all these opinions that OLC is releasing, Congress has to, because you guys are the ones who are legislating. Members of Congress are the ones who are writing these laws, and they have no idea how it's being interpreted unless it gets to court, unless the administration wants to put it out themselves.
Can I say something really short on that, to the role of Congress out here? Those of us who FOIA OLC a lot, so we all talk to each other, and OLC is one of those offices that's pretty bad about being consistent. And so she might get this bottom list and I get a redacted list. And someone who's just FOIAing on their own, who's like a small town reporter in Des Moines, may get no list. And so that's why, most of us here, if not all of us here, are strongly in favor of things like the legislation that says that at least the list has to be put out that, by the people who have the authority, Congress, to say, look, make sure everybody's starting from the same place. Because there have been cases where I have talked to someone like Liz, and I have found out that something I'm fighting against, she already has. And when you're dealing with that kind of arbitrary nature of FOIA processing, it becomes imperative that somebody say, enough is enough, and even if they can't enforce consistency, at least they can ensure sort of a minimum level of common awareness.
Michael, can you comment a little bit on, I think the separation of powers, especially considering we're talking probably to most of the staff here, can you talk a little bit more of the separation of powers issues that are at play? Because in FOIA is obviously a very powerful and important tool, generally thought of as a public-facing tool. So, from the congressional side, I know you already described how it can be hard, but what if Congress has a different legal opinion than the executive? And, would Congress know that? Would, if the OLC, would those OLC opinions be public? Would they be made available to you? I mean, all of these other questions that are naturally coming out of the context that we just did.
Well, I mean, as the example I gave earlier, there have been cases where, basically Congress is in a position of dealing with a legal interpretation that they can't get the explanation for, like what it's based on. So that's basically a secret law, right? That the administration says we're following the law, but we're not going to tell you why we concluded this is what the law is. And that happens from time to time. I kind of get the sense that is not the biggest problem right now. There's also, I guess, a related problem, which is comes up with that absolute immunity opinion Liz was discussing earlier, which is OLC says we have this position and we're basing it on prior OLC opinions, but a lot of those opinions are not actually public.
Yeah.
And when they are found, it turns out they don't actually necessarily say what OLC was claiming that they said. And that was in fact a big problem with their argument on the absolute immunity, that it went back to a opinion that then head of OLC Bill Rehnquist wrote, but really it turned out that it was much narrower and a lot more informal than what OLC's current opinion purports to be. So that is a problem. I think to the extent that OLC is simply acting as an advocate for the interests of the executive branch, it maybe doesn't matter as much. Congress shouldn't feel like that has any particular sway on Congress at all. But I think people do tend to wrongly give them more deference than they should be entitled to. Well, that really goes to the executive. I mean, that's their power over the executive branch, right? I mean, in former executive branch people. I don't think that
it goes to what the efficacy of this.
Right, and in that case, what Congress ought to say is, well, it really doesn't matter what OLC says. It doesn't have any more sway than what any other lawyer for the executive branch says.
How would they mitigate that?
Well, that is we could have a whole other panel on that.
How long do we have?
Yeah. So,
well, actually, I do want to keep time for at least a couple of questions. And so I'm just gonna throw, and if your last slide ends up being this, you're welcome to continue there, but I'm gonna just pause and invite everybody, especially considering we're talking to a number of staffers here. What's the one thing that they should walk out of this room keeping in mind about OLC?
Only one?
Yeah, and I'll start by picking up on what Michael just said.
one reason since I've left OLC that I've seen people take OLC advice very seriously, because OLC lawyers tend to be very well-trained lawyers, and are from kind of the elite establishment, and have the luxury of time. They have the luxury of the time in the way that the White House counsel's office doesn't, and in the way that I know you congressional staffers do not have. And when we're talking about ways to counterbalance some of the influence that OLC and the president's lawyers have, transparency is really, really important. But I take a yes and approach. Yes, transparency, and also more time and more, I don't want to say more effort, because I know that all of you are like running around working 24 hours a day, 7 days a week, so it's not a matter of effort. But be that Madisonian counterbalance. Let Congress's ambition counteract the executive's ambition. And that can be through legislating for things like transparency, for more staff for yourself, so that you all can actually spend the time to do legal analysis that takes Congress's prerogatives into account. And kind of when it comes to OLC, be the change you want to see in the world. That sounds so cheesy. I'm sorry, but I'll end on that note.
I would say two things because I'm going over. One is to continue, is just to second what Eric said and have some skepticism when you get thoughts back from DOJ or the Office of Legal Counsel saying that the legislation you're working on, especially if it purports to kind of limit some of the president's authorities or abilities to do whatever the president is doing that your office is taking issue with that day. Is look at it skeptically. You don't have to follow. OLC is not the final word. They're not a court. They're not a judge. They're not a Supreme Court. And then second would be to recommend to your boss to co-sponsor the OLC Sunlight Act, which is great legislation from Representative Quigley and a few others that would provide some of this really necessary transparency around what are the opinions that OLC has issued to kind of put you on that even playing field.
So I'm going to take a bit of an in-the-weeds approach to this, since they've amply covered, all the things that are directly impactful on OLC and on public access. Show of hands, who here is a Senate staffer? Okay, then most of this is aimed at y'all, because I'm going to talk about something that has already passed the House unanimously. There is something called the IG Access Act, Inspector General Access Act. This corrects a weird discrepancy at DOJ that says that DOJ lawyers are not subject to the DOJ Office of Inspector General. They have to go, any complaint, any review of them has to go through an office called the Office of Professional Responsibility that does not have a good track record of being good oversight. That includes all of OLC. So when we're talking about how OLC sometimes plays fast and loose with the rules or hedges their timelines or does things that would get any practicing lawyer in trouble, keep in mind that the IG cannot look at that. And so it is currently waiting, as I said, it passed in the House. It has not passed in the Senate. It has not been brought up for a hearing in the Senate or a vote. So for those of you who work in the Senate or those of you who have impact in the Senate, get that done, because the IG system is one of the best ways to ensure that the executive branch, the people who do not have issues and can read anything, privilege doesn't protect something from the IG, that they are given the ability to self-police, to maybe get rid of a lot of the issues so that you don't have to.
So the one thing I would say is that both the House and the Senate ought to have oversight hearings on OLC, and call in Mr. Engel and ask him what he's doing and ask some questions about these various opinions that they've issued over the last several years, and see whether they're following the best practices memo that they still have on their website. So theoretically, that's the policy of the office. What's that?
Labeled as best practice.
Yes. it's
Best
labeled as
practices
best
for
practices.
OLC legal advice and written opinions.
Exactly. I'll just, if I could mention one thing, one success story that I can remember in recent years. OLC did come out with a memo early in the Trump administration that basically said when a ranking minority member of a committee asks for something, it doesn't have it is basically treated as a sort of like a FOIA request. I mean, it's nice. They'll get to it if they want to, but it will not be treated as a committee request or given any sort of, special preference. And Senator Grassley, despite being in the majority, seriously opposed that and wrote very strong letters, I believe, not only to OLC, but to the president, and rejected that. And during Engel's confirmation hearings, he basically was forced to say, well, we'll take another look at that. Maybe that was a little. So, if you have some pushback, sometimes you can get them to back off things.
But that opinion is still there.
Yeah.
They haven't rescinded it.
That we know of.
But they say
So-
they're not following. Yeah, but it's
Good
still
point.
there. It's still there to justify
Right.
ignoring any request from a minority member.
So that would be a good thing to have an oversight here,
Yeah.
especially on the Senate side.
Thank you very much. I am about to ask or invite questions, so while you get those ready, if you have any, I'll just quickly flag. So on the desks, we have a one-pager that's about the OLC Sunlight Act and a support letter in that territory. There's an op-ed that I did with a colleague from Americans for Prosperity. And then the fourth item is perhaps the bill. The bill's all been taken. Okay, well, there might be a fourth item in this case. And with that said, does anybody have questions? No questions. Well, I'm
We
gonna
were
ask-
that good.
I'm going to ask one last question, but I think we're going to be wrapped up. Actually, it is now 3 o'clock, so it's done. I have one more question. I want to do want to ask something, but please, I'm sorry, I don't need to keep you here. You mentioned the OLC Sunlight Act. What have reform efforts here look like? I think it's probably useful for people who are interested in getting involved in this, or bosses are interested in getting involved in this, for them to know what maybe the background is. I don't want to spend too much time there, but what does the current effort look like? What is the goal in the long term? Is this just about transparency? Basically everything in this territory that you've all followed for so long.
Well, I think most of the legislative efforts have been around transparency, and I think that makes sense because again, we don't really actually know the problem that we're trying to solve here. We know conceptually, we know generally, but the scope of the problem, I think, is still out of our grasp. And I will say, I'll just talk about my favorite failed attempt. It was in the last round of FOIA reform. There was a big push to get OLC to be subject to FOIA that failed at the last minute. The bill was getting pushed through the Congress in the very last minutes that they were there. So that piece was dropped because it was too controversial. But there is a lot of resistance to increase transparency around here, and I think
What administration was that?
that was during the Obama administration. And so yeah, I mean, the transparency issue with OLC is not unique to this administration at all. But yeah, I think, there is a reflexive reaction against increased transparency around this office. I think it's kind of understandable when you think about what lawyers do and legal advice, but it doesn't square with how DOJ treats OLC opinions. So they need to pick a lane. So they're either binding or they're not. But you can't have it both ways, and you can't say no to transparency because it's just advice. By the way, you better follow that advice. So yeah, it's a checkered history of transparency attempts.
And this is a little tangential, but it illustrates this point. So a few years ago, a PhD student did a study of OLC opinions and came back with these really remarkable statistics that over 3 decades, 92% of OLC written legal opinions to the president supported what the president wanted to do. And that's not because all of those presidents had really great ideas. And stuff like this, these are only the things that we see. And as she's talking about, we got to know what we're fighting. We got to know, when you look at lists of OLC opinions, I used to think that they would be easy to tell when one was missing because there'd be a gap in the number. But that's not even true necessarily. Sometimes I have gone into sort of FOIA'd 10-3, or I forgot what the numbering scheme was, and this one it doesn't exist. But there's a 10-2 and a 10-4. And so when we talk about these legislative issues, and I was sort of in the room when that happened a few years ago too, and it was very frustrating. It is important to remember that this position, that OLC is acting as the executive branch's lawyer, goes back decades. And that's what you're fighting against. And that's why they fight so hard against even the little chink in the armor of getting a list of the opinions so that you know what they're withholding. Because once you get a peek behind that curtain, it becomes more obvious that they're doing things that we don't necessarily think they should be doing. And that's why it's important to go after the little wins, even if you don't get the big ones.
I'll defer on the legislation. You just reminded me of the term that Posner and Vermeulen came up with for the Office of Legal Counsel, which is the keeper of the executive fig leaf, which I think is a pretty good description of what the office does historically.
Well said. Eric? No pressure.
I don't think I have anything to add to what these fine people have said.
Well, thank you all, and I'm sure a few of us will be around for a few more minutes, so if you have any questions you didn't want to ask in front of everybody else, please stay around, and help me give a round of applause for them.